G'day everybody and welcome to Laws 11061, Contracts A, Topic 5. I'm Anthony Marinac. This week we're looking at a topic called consideration. Consideration is a bit of an unusual term, I guess, because when contract lawyers talk about consideration, they mean something quite different to what normal people mean when they use the word consideration in daily life in the normal English language. Consideration is essentially the thing which makes a promise into an enforceable promise, because the person who's receiving the promise actually provides something in return for the bargain. So consideration is the price of the promise. What are we looking at this week? Well, for starters, we'll talk some more about the basic concept of consideration, what it means, and why we have it as part of contract law. And we'll go through actually identifying consideration, because there's various types of consideration that can be given. And one of the things that you will need to do when you are starting to assess whether a contract is actually in existence or not is have a look and see whether you can actually identify the consideration which has been given in a particular situation. Then we'll look at the criteria for good consideration. Not everything can be consideration. There's a number of types of payment or return promise that will not make valid consideration. And so we look at whether the consideration was bargained for, whether it's past consideration, whether it's merely reflecting an existing duty, whether it's actually given by the person who's receiving the promise, and whether the consideration has any value. Finally, we'll come to what's called the rule in Pinnel's case. And this is a very old rule that has to do with satisfying a financial debt, and it's definitely one that you'll be expected to know, one that pretty much all lawyers are expected to know. So let's start with the concept of consideration. I'm sure that some of you out there have read Robert Jordan's Wheel of Time series, and there's if you haven't, by the way, fantastic series. If you do get any time to read for pleasure, definitely worth picking that one up if you're into the science fiction fantasy genre. In that series, there's a village called Taran Ferry, and one of their sayings is a cat for a hat or a hat for a cat, but nothing for nothing. And that's pretty much the neat summary of the rule of consideration. A contract, you see, is an exchange. For a contract to be in existence, there can't be one party which just receives stuff. For a contract to be in existence, both sides of the contract must give something, and in most cases, both sides of the contract will get something. That's what differentiates a contract from a gift. If, on the other hand, there's no consideration, and that's what we call nudum, a promise which is nudum pactum, it's not enforceable, because all you've got is a promise that is not supported by any form of liability or any form of payment or any form of sacrifice by the other party. So we have to say, what interest does the other party have that we might want to protect? Now, the example that I've given in the notes sets that out pretty well, I think. Let's say we've got two friends and we've invited them both to come over to our place for dinner. One of those friends has paid us, they've paid us $20 for this dinner. The other friend has not. So we've taken the $20 from our first friend and we've reassured everyone that the dinner's going to happen. And then eventually we decide that we're not up for it. So we send a text message to both friends. We say, look, dinner, we're going to have to cancel. Very sorry. Now, both friends might be disappointed, but the friend who pays us $20, that friend's in a bit of a different position, aren't they? Because they're going to turn around and say, well, no, hang on, I want my $20 back. You see, they've given something. And because they've given something, they end up with an enforceable right. It's perfectly reasonable for that friend to be saying to us, look, either you give me my $20 back or you cook me a dinner. One of the two. That was the deal. Whereas the friend who simply got invited around for dinner, they've got no such recourse, have they? Because really they haven't done anything to earn the obligation. It's just been given to them gratuitously. And so on that basis, it could be withdrawn at any time, and they really haven't lost anything. They've perhaps lost the expectation that they were going to have dinner cooked for them, but they haven't lost anything that they have actually given. So you can see that in order for the court to come and protect a contracting party, the court has to say, well, have you got an interest that we can protect? And consideration is the way that that protectable interest is established. So how can we give consideration? There's three ways that you can give consideration. It can be an action, it can be a forbearance, or it can be a promise. Most of the time, in most commerce, consideration is given by means of an action. So let's take the basic contracting situation where you're making a purchase of goods at a shop. Now, we know from previous weeks that the display of the goods in the shop is merely an invitation to treat. You pick the goods up off the shelf, walk up to the counter, and the contract takes place at the counter. You make an offer, essentially, by handing the goods over and saying, yep, I'll pay the price on the price tag. The offer is accepted by the checkout operator on behalf of the company when they accept your payment, and then they give you the product. Now you can see that both sides there have conducted an act. You have conducted the act of payment, and the other side has conducted the act of giving you possession and ownership of the goods. It's probably even clearer if we talk about a service type contract. Okay, you've been working out hard in the gym, you decide to treat yourself to a massage. You go off to the sports massage place, you pay them money, and they give you a massage. Okay, so you've done an act, paying money, they've done an act, massage. Act for an act. Simplest form of consideration. The second type of consideration is called forbearance. Now, forbearance is not acting in circumstances where you might otherwise have acted. So in other words, if somebody agrees not to do something, that can be consideration. So let's say I owned a vintage car, beautiful vintage car, and I was thinking of getting rid of it simply because I'd finished the project of doing it up. I'd never drove it anywhere, it was just taking up space, and what I'd really like to do is convert it into money so that I can start a new project. I've got a friend, and this friend desperately wants to own this car. And I say to the friend, look, I'm going to put it on the trading post. And the friend says, no, don't do that. Look, if you can give me 6 weeks, I'll be able to get some money together and pay for it. And I say to the friend, look, I really don't want to wait 6 weeks, mate. I want to get rid of this thing now. I want to turn it into cash. And the friend says, look, I'll give you $20 right now. If I give you $20, just hold off for 2 weeks. Give me 2 weeks. Now you can see the friend has given consideration for the promise. They've given actual cash money. What have I given in return for that cash money? Well, I've given a forbearance. I've agreed not to act. I've agreed not to sell the car. I've agreed not to do something which I might otherwise have been able to do. Does that mean I've given something up? Well, yes, I have. I've given up the right to sell my car. And that has a value. That means that I have done something in return for the cash payment that I've received. Hey, that means we've got an enforceable contract. The third type of consideration, and this is something that you will come into very often in contract law, is a promise. Giving a promise is a form of consideration. And this happens very often, particularly in commerce, where many contracts are prospective in nature. So what they're looking at is things that people are going to do in the future, setting up a joint venture or something like that. So let's say you're establishing a new business and you're going to run a bakery delivery business. So you're going to take bakery goods from a wholesale bakery and deliver them to cafes and school tuck shops and wherever else these goods might be needed. And I'm the baker. You're starting to set up your business. You're not in a position to actually do anything yet. So what we do is we put together a contract whereby you promise to undertake the delivery of all of these goods for me, and I promise to pay you a set rate for doing so. Now, at the time of the contract, neither party is going to be giving anything, because the actual performance of the contract might be weeks or months away. But each party is making a promise, and those promises have value. So you can see that a promise can be good consideration, because what you're really doing there is you're swapping an obligation for another obligation. It's just that both of those obligations are off in the future somewhere. So if you're presented with a situation, with a problem question, and you're going through your elements of formation and you get to the question of consideration, you're going to be asking yourself, well, has each party either performed an act or forborne to act or given a promise in return for whatever promise or action is done by the other side? Can I identify an act, a forbearance, or a promise which forms the consideration? Someone should be able to turn around to you at any time and say, well, what was the consideration in this contract? And you should be able to indicate, here's the consideration. Now, there are some rules about consideration. Sometimes parties will give something that initially you think this looks like consideration, and then you suddenly realise, actually it's not. It doesn't work quite the way that it looks on face value. The first rule is that consideration must be bargained for. What do we mean by that? Well, when we say consideration must be bargained for, what we mean is that both parties have to agree to the consideration ahead of time. So consideration has to be sorted out as part of that process of contract formation. You can't simply say, I've performed a service for you, therefore you now owe me something. Because those services which were performed were not performed in response to any obligation. Now, the example that I've given the hypothetical example that I've given in the notes is a neighbour saying, look, I've mowed your nature strip 20 times and in return you need to help me on this one occasion. Now, they might well have a very valid moral claim, but they certainly don't have a contractual claim, because when they mowed the nature strip those 20 times, they did so gratuitously. They didn't do so out of any obligation. So it's not as though they have swapped that obligation on their part for an obligation on your part, because they could have stopped mowing the nature strip at any point in time and you would have had no recourse. It's not as though they were under any sort of an obligation to do it. So that's the first thing you need to be looking for. And what you can do is you line up this idea of consideration alongside your process of offer and acceptance. So what you're saying is, was this question of consideration of what each side of the case is going to do, was this taken into account as part of the process of offer and acceptance? And usually you can spot it pretty easily, because most contracts put the consideration pretty much up front. I will do this for you if you do this for me. The next rule for consideration is that past consideration is no consideration. What that means is that, generally speaking, if someone has already performed an obligation, that can't be consideration. The reason for this is that it's already been performed, it's already been done. There's no point somebody saying as part of a contract, I will take on a certain obligation, if they've already completed the obligation. What would be the point of the contract if the obligation has already been completed? The example from the case law, a great case, Roscaula and Thomas, looks at the purchase of a horse back in the 1840s. Don't you love that about contract law, that you're always looking back into the deep dim past of history and dealing with the law of a bygone era? Well, in Roscaula and Thomas, there was a horse being sold, and the sale happened. Okay, the contract was made. The contract was fully effective. All of the elements of contract formation were there. And subsequently, one of the parties made promises about the quality of the horse. He said, essentially, you've bought this horse. Look, it's a great horse. Okay, it's free from vice. It has no problems. It's a good one. Enjoy. They've gotten the horse home, and it's not free from vice at all. And he's come back and said, no, hang on. You told me this horse was A-OK, and now I find that it's not. Well, can you see that he's got no case? Because had he wanted to get any guarantees from the other party about the condition of the horse, he should have done that before the sale took place. He should have made that a condition of the sale. When the sale's taken place, when everyone's performed their obligations under the contract, it's a bit late then to be saying that, oh, well, subsequently you made me some promises about this horse and I'd now like to hold you to those promises. It really doesn't work that way. Except maybe it does. Most of the sort of contract, well, most of the complicated contract law takes place in the context of business, and it's businesses dealing with other businesses who are making the complex contracts. In most business environments, it is helpful and sometimes critical to establish ongoing relationships with suppliers and with business partners and with other operators in the market. And you'll remember right back in week 1 when we talked about theory of contract, we said that contracts occur within relationships, and sometimes the relationship is more important than the contract. In the context of an ongoing business relationship, it's quite reasonable that sometimes work is going to be performed or goods are going to be given in anticipation of a contract, and that under some circumstances it may actually be that the consideration was given ahead of contract formation, but that both parties understood that that was intended to be consideration. How do the courts work this out? Well, they work it out by applying, yet again, an objective test. They work it out by saying, look, would a reasonable person in the position of the parties have considered that this past performance of a service or past giving or doing of an act was intended as consideration for the new contract? And if the answer to that is yes, then sometimes past consideration will be consideration. So whilst you need to know that this rule is not applied 100% of the time, you do need to understand that past consideration is, generally speaking, no consideration. So when you're going through a contract or a contract problem and you're starting to ask yourself, is there a contract? If there's consideration there, but the consideration was given prior to the formation of the contract, your spidey senses need to be tingling. Okay, you need to have all sorts of alarm bells going off in your head. You can then ask yourself, look, can we really say that a reasonable person in the position of the parties would have seen this act, forbearance, or promise as having been consideration, even though at the time the act, forbearance, or promise was undertaken, there was no actual contract between the parties? That will give you your answer. That will tell you whether or not the past consideration can actually be considered consideration. In general, though, your starting point and your finishing point is going to be that past consideration is no consideration. The third rule we need to look at for valid consideration is the question of existing duties. Usually speaking, an act, forbearance, or promise that's undertaken in accordance with an existing duty cannot be consideration. Why? Well, if the idea of a contract is that each party gives an obligation to the other, you're not really giving anything if you're only promising to do something that you are already obliged to do. So let's say that you and I make a contract, and the contract is that I can drive your car for a week, provided, and in return for being allowed to drive your car for a week, I say, right, well, in order to do that, I will reward you by agreeing that I will only drive the car at or below the speed limit. Can you see that I really haven't given anything there? I'm really just taking the car for free because I'm already obliged to follow the speed limits, and the law is already going to step in if they catch me if I don't obey the speed limits. So I haven't given anything, I haven't done anything. As a result, there really is no consideration. This is the same whether it's a pre-existing contractual duty or a pre-existing public or legal duty. Let's have a look first at whether there's a situation where there's a pre-existing contractual duty. And we'll go back to the example that I keep using, a very simple example of somebody mowing the lawn. Now let's say that you and I agree that I can mow your lawn and you'll pay me $20. You pay me the $20 and I don't mow the lawn. And you come back to me and say, hey, Anthony, what about my lawn? And I say to you, look, I'm really sorry. I know that I haven't mowed it. I'll tell you what, let's make a new contract, and the new contract will be that if you provide me $10 now, in addition to the $20, I'll mow your lawn. Can you see that that's unfair? Why should you have to pay me the extra $10? I'm already under a duty to mow the lawn because we already had a contract which imposed that obligation on me. So how can that same act, which has already been secured by consideration, it's already been paid for, how can that form the basis for a new contract? It really can't. It's the same with a public or a legal duty. Let's say, the example that's given in the cases, which is Collins and Godfrey, you've got a lawyer who was called upon to give evidence in a court case. Now, if you're called upon to give evidence in a court case, particularly if you're summoned to give evidence in a court case, you don't have any choice. You're under a duty. And so this fellow's turned around and said, well, hang on, if I'm going to be going and giving evidence in the court, I want to be paid by the person who's called me. I want to be paid my normal hourly lawyer's fee. How do we feel about that? Do we really think that the lawyer should be paid the fee when what they're actually doing is responding to or complying with exactly the same duty that anyone else in any other profession has to comply with if they're giving evidence in a court case? Why should the lawyer be paid extra in order to comply with a duty that they already had? Well, the answer, of course, is that they shouldn't. So you can see that where there is already an existing duty, the mere performance of that duty is not somehow consideration for any other promise. Let's look at the next rule. Consideration has to move from the promisee. So if you're receiving the promise, you have to pay the consideration. Otherwise, on what basis could you possibly sue? So let's say my mum was living with my wife and I for a few weeks, and she decided that she would get the lawns mowed for us. So she's made an arrangement with a neighbourhood teenager for him to mow the lawn for $20, and he's failed to do so. On what basis could I possibly sue him? I couldn't. I haven't given any consideration. I haven't done anything to give him an obligation to me. Perhaps he might have an obligation to my mum, but he wouldn't have an obligation to me. Can you see the point? In order to make, the whole concept of consideration is that in order to make a contract or an obligation enforceable, you need to give something in return for it, which means that only people who actually give consideration in relation to the contract are going to be able to sue. So it has to move from the promisee, from the person who's meant to receive the benefit, from the person who's proposing to sue. Finally, consideration has to be valuable. Now, generally speaking, in most commercial settings, we look at a contract and we can see that it's a reasonably fair deal. Depending on the negotiating powers of one side or another, one side might be making a greater promise than another, but you can usually see that both sides are getting something out of the deal, even if one of the sides is eventually running up a loss. And so a lot of people get the idea that consideration has to represent some sort of approximately fair value for the obligation which is being given. We need to get past that because it's not actually true. The consideration doesn't have to represent fair value at all. However, the consideration does have to have some value. It does have to have even the slightest level of value. In the cases, they talk about what's called peppercorn consideration. Now, a peppercorn, as those of you who love food will know, is basically the whole dried grain form of black pepper. It's what they're grinding up using big wooden grinders in pretentious Italian restaurants all over your pasta. A single peppercorn is worth essentially nothing. A single peppercorn might be worth 1 cent, and we don't even have 1 cent pieces anymore. But a single peppercorn could be legitimate consideration for the purchase of a house. If someone will make that deal with you, if you say to someone, I will swap you this peppercorn for your house, and they say, yes, no worries, let's do that, it is a valid contract because both sides have given consideration, and the consideration on both sides is valuable in the sense of able to be valued. It is possible to place an economic value or a value in a personal sense on what's being done by either side. Now, what about promises? Because sometimes promises won't have any economic value at all. Well, we're not just talking about economic value. There can also be personal value in a promise, particularly within the context of ongoing relationships. This can be very important. So when you're assessing consideration, when you're assessing whether or not a particular contract actually exists, one of the things you need to be thinking about is, does the consideration actually have any value? If the consideration doesn't have any value, then this is what we call an illusory consideration. Okay, it's something which might even appear to be consideration, but really isn't. And we give the example in the notes of the case of Dunton and Dunton, which was an 1890s case where Mr. Dunton sadly had found himself saddled with a wife who was a drinker, had a drinking problem. And this is the 1890s, so one couldn't just walk away from a marriage. It didn't really work like that. The best they could do at that point was separate, and they did separate. And Mr. Dunton said, right, well, because I'm separated from you, I will pay you an allowance, essentially an alimony, of £6 per month. But in order to get that £6 per month, you've got to lay off the booze. Okay, you have to behave with sobriety and in a respectable, orderly and virtuous manner that will not subject me to hate, contempt or ridicule. Now, at first glance, you think, well, okay, that works. He's swapping £6 per month in order for her promise, like in return for her promise, to behave in an appropriate way. But then when you look at it again, really what's she promising? I mean, how will we know? What are we going to set up an umpire to say whether or not she's behaving with virtue in any particular situation? What are the limits around it? Is she required to behave with sobriety and virtue in her own home, or just when she's out in public? And how does she know whether or not her conduct is going to subject him to hate, contempt or ridicule? Because doesn't that very much depend on the reactions of the people who are engaged in the hate, contempt or ridicule? Once you look at it carefully, you can see that in fact what is claimed as being consideration on her part really isn't consideration at all, because it's not something that could be enforced. It's not even really something that could be understood. So it's illusory consideration. So one of the things that you need to be looking at, and you'll see when you follow the flowchart for this week's material, is you need to be thinking, is the consideration actually valuable? And you need to be able to point out what the value of the consideration actually is. Finally, then we come to the rule in Pinnel's case. The rule in Pinnel's case is a variation on the general rules of consideration, and it applies only to cases where we're talking about a contract that has given rise to a debt. So the situation is that two parties have engaged in a contract, and the result of that contract is that one party has a debt to another, a financial debt. Let's say in this case the debt is owing $100. You can't come along after that and make a new contract and say, look, I'll tell you what, I acknowledge that I've got a debt of $100. My intention is to pay you $80 and you discharge the debt. You say, okay, if you pay me $80, then we'll call it even. Why doesn't that work? Well, it doesn't work because I'm already under the obligation to pay $100, aren't I? And we already know that past consideration is no consideration. So really what it amounts to, what the second contract amounts to, is the person who's owed the money basically giving me a gift of $20. They're saying, okay, well, you owe me $100, you can pay $80. That's really another way of them saying, I will give you a gift of $20 because I've given you that $20 previously, and now I'm saying you don't have to repay it. That gift is nudum pactum. That gift is not supported by any consideration at all. And so the rule in Pinnel's case says that part payment of a debt cannot be good consideration for the discharge of a whole debt. However, that's a bit odd, isn't it? Because this sort of thing happens in commercial arrangements all the time, where part of a debt is forgiven. So the rule in Pinnel's case has a bunch of exceptions, and you need to come to understand the exceptions in order to understand the rule. The three key exceptions I've listed on the slide there. The first is that the rule in Pinnel's case does not apply if a third party makes the payment. So let's say I owed you the $100 and my father gives you a call and says, look, I know that Anthony owes you $100. He can't pay it. I can pay you $80 right now. If I pay you that $80 right now, will you discharge the debt? Now you can see that that's an entirely different contract because my father's not under any obligations at all. So he's not under a pre-existing duty. So he is giving good consideration. And his consideration takes the form of an act, that is the payment of $100. The person who's owed the money is also giving consideration in that contract because what they're agreeing to do is they're making a promise. Well, you can see it one of two ways. You could either say they're making a promise to forgive the debt or they're making a forbearance to collect the debt. So as between those two, as between my father and the person that I owe the money to, there is a perfectly valid contract because both sides are giving new, fresh consideration. The second exception is that the rule doesn't apply if the payment is a bona fide settlement of a legal dispute. So you might have two parties who are in a legal dispute about the debt. Legal disputes cost a lot of money. Lawyers cost a lot of money. Courts cost a lot of money. And so one side might say to the other, look, you can either waste money pursuing me for this debt, or you can take 75% of the debt right now, and we can call it even Stevens. That's going to be attractive in a lot of cases. So if it does reflect the bona fide settlement of a dispute, then both sides are going to be relatively happy, and certainly both sides have given some sort of consideration. Finally, the rule doesn't apply if it confers some other sort of benefit on the creditor. Okay, so if I owed $100 and the terms of repayment were that the $100 had to be paid by the end of October, but I know that the person who I owe the money to has a cash flow problem, and I say, look, I can pay you $80 and I can pay it by the end of July, but I can only do that if you forgive the rest of the debt. Now you can see that that changes things as well because there is a benefit that is coming to the creditor in that situation. The benefit to them in that situation is that they don't have to wait as long for their money. And so that benefit, that speed of repayment, can form consideration on the part of the debtor. So what does the creditor get out of it? They get their money earlier than they would have. What does the debtor get out of it? They get the right to repay only $80 instead of $100. So both sides have given something to the other side in order to secure the promise or the obligation. Boom, we have a contract. The rule in Pinnel's case is a little bit complicated, and it's very easy to find yourself running around in ever-decreasing circles trying to understand it. Give the notes a read, have a look at the case itself, and then perhaps come back to this bit of the lecture and hopefully it'll make a great deal more sense. If it doesn't, then I'd really encourage you to participate in this week's tutorial and I can have another go at explaining it in response to your questions. So that brings us to the end of topic 5. We've had a look at the concept of consideration and the fact that consideration is what really tells us whether obligations or promises are enforceable or unenforceable. We've looked at the things that have to be examined when we have a problem question and we're trying to work out whether the elements of contract formation are present. These are what we're looking for with consideration. Has it been bargained for? Is it past consideration? Is it just the performance of an existing duty that a party was under anyway? Has the consideration moved from the promisee? And does the consideration have any value? Finally, we looked at the rule in Pinnel's case, that rule being that part payment of a debt cannot be good consideration for the discharge of the whole debt. And we've said, well, actually, it's the exceptions to Pinnel's case that make it work. And we've looked at a range of those. All right, well, I hope that this week's lecture has made some sense for you. And I'll look forward to topic 6 next week when we talk about certainty and completeness, and we actually bring our study of the formation of contracts to a close. Have a great week.